All right, guys, we'll kick that off. I think, well, largely everyone's here. It's still a much better turnout than last week. So, today, as promised, is the final week of actual lecture material. So things that you will be examined upon. Just bring this up on the screen. Hopefully. There we go. No sound. And today we're going to talk about the Ombudsman, and in particular the Ombudsman in relation to their role in our system of government in terms of administrative law. Now, to be honest, the Ombudsman is something that I could probably explain to you guys, and I will, in about 90 seconds. In terms of what it is and what it does and how it sits in this framework. So it's going to be 90 seconds worth of explanation and then another, 40 minutes worth of this bit of statute and that bit of statute. And I will specifically go over the examination question you guys will have to do with the Ombudsman in the tutorials. So we'll do a little bit today. And as you guys are aware, next week in the same time slot for the lecture, we're going to be doing a full revision. So, with that caveat, while here we're encouraging you guys to develop a deep understanding in terms of where the Ombudsman sits in our administrative framework, their importance in terms of controlling government action. Really, it's knowing to tuck the bits of information you know about the Ombudsman in terms of what they do, and then when problems arise, to use it. And in some ways it can be something of a one-stop shop in terms of an administrative law remedy. Usually when you don't want to get involved with something in terms of going to the AET or seeking some form of judicial review. Now they do, and I'm not trying to be cheeky about that, they do, the Ombudsman does form important part of the system, but the key thing to note about the Ombudsman, again in 90 seconds, is that the Ombudsman can't do anything, or at least can't create any orders or exert any form of coercive powers other than the obtaining of information and the reporting of that information to other parties, or in some situations back to Parliament. That's the key thing to note about the Ombudsman, that they do not have coercive powers other than the obtaining of documents. And to be honest, they actually have really strong powers in terms of that process to get the information off government agencies, and as we'll talk about too, sometimes private citizens as well. So that's the key thing to note. Another really key thing to note, although it's a little bit more theoretical than practical, is that the Ombudsman, at least the Commonwealth Ombudsman, again by default, and some of these other independent bodies we talk about, the Ombudsman is not, strictly speaking, a government department. The Ombudsman is an office which is created, but reports, and most importantly, is funded directly by Parliament. So there's a specific Law and Governance subcommittee in the Federal Parliament which meets and goes about managing things to do with the Ombudsman. That's this key part. It's independent, it has powers to investigate and to report, and from time to time to refer matters too. It can refer matters to the AET or to the Federal Court, refer questions of either fact or law to those bodies, but it cannot create coercive orders. That's this key part. I like to think of it as, again, I come from an IT background, it's read-only, essentially. It can't do anything, it can't make any changes other than recommendations to various bodies. Okay. And as a result, there's not a lot of, really, a lot of case law. I haven't put a lot of case law into this lecture. There's not a lot about specifically the role and function of the Ombudsman themselves. The term, by the way, strictly speaking, it's a gendered term, but it's a bit like ACTA, the term actor these days is used to describe what would have been male actors and female actresses. The term ombudsman, I suppose, includes ombudswoman. I think if you listen to Jamie's lectures, he mentions such things with a bit more of a comical tone than me. It's, you know, again, I'll run through just quickly the history of the ombudsman for your own background knowledge. Ombudsman, as you can imagine, is a very unusual word, isn't it? Sounds a little strange. It's Scandinavian. Sweden was the first nation to have this. They actually had it a very long time ago, about 200 years ago, to create a body that related to this. And so the word that we use flows from the Nordic tongues. And crazy. And so it's helpful to sort of appreciate that while Australia is really good in terms of best practice in having these independent agencies, and there are many, and I'll talk about some others as we go through this lecture, that it wasn't Australia didn't come up with this. But by and large, the Australian government has been very good at setting these things up and letting them go off to do their own thing. Okay, so formally, again, the Ombudsman, remember, was part of these administrative law changes that they made in the 1970s. There was acceptance, and by the late 60s, early 70s, that things needed to change. And you'll know that there's a non-trivial number of statutory frameworks that we use in this day and age, both in Queensland and the federal level, that changed in the 70s as a result of society changing. This came from this massive changes that happened in the 1960s period in human history that it may seem a little trite. I mean, my parents' generation, probably for you guys, your grandparents, that it was transformative. And part of that is really appreciating that law, by and large, didn't really work for citizens. Most of the time, people actually benefited from the government stepping in, and in order to do this and having the government to step in all sorts of areas, particularly things like the Family Law Act. It's not coincidence that popped up at around about the same time as these administrative functions. This plethora of government agencies that appeared in order to regulate areas of life that traditionally, remember, the courts kept away from. You guys remember state run contract, family law? You didn't go anywhere near it. But from as the result of the changes in the 60s, the public demanded that these systems be put in place. And so the Ombudsman was just one of many things. The AAT Act, the Freedom of Information legislation, and changes things like the Federal Court Act as well. All of these things. And of course, the one we did largely for this particular subject, which is the ADJR. Yeah, good, that's right. And so the Ombudsman statutory framework was put in place. It hasn't had a huge number of changes in terms of how the thing looks. It's quite readable. There have been some large sections that have been inserted actually to create separate ombudsmen, separate offices. So the way they've done that with some of the federal ones is to just insert big chunks into that act and say, okay, this is the private health ombudsman. We'll just plop a whole bunch of these. So if you do see section 17, capital A, capital B, capital C, that's how that's come about at a later stage. And for the purpose of this lecture, we're talking about the federal, the Commonwealth Ombudsman and their roles. I'll talk briefly about the Queensland one. Most of the things apply in terms of the rules and structures and really the purpose of the Ombudsman at the state level. But just make note that the sections, which feel free to go through and find the equivalent Queensland one. In fact, you might do yourself a great service through finding the equivalent Queensland one and just making note of those. Store them particularly in your notes for your exam. Okay, the 2 points on the slide: investigating and now again, this investigation component really comes in two flavours. They can get complaints from the public. Hey, I didn't get my Centrelink on time because they did this, this, and this. Can you help me? they can go take that matter of complaint and go with it and investigate it. They can, however, often through the process of doing this investigation and realising there's some form of latent defect that isn't strictly related to that particular complaint, but may be bubbled up through the office of the Ombudsman themselves. And if that happens, they can initiate investigations of their own volition. The Ombudsman can decide to go and investigate things, even where there isn't a complaint. It's a bit more proactive than certain things. So it's not quite like our courts, for example, which you can only go to court for something that's already happened. Okay, so those are this core function, this idea of going and doing this investigation, and then after doing this investigation, then reporting it somehow. Now, the Commonwealth Ombudsman is the umbrella term, and the Commonwealth, and you can kind of see how this works. Look, the Ombudsman's just, in the broad sense, not going to have the depth of staff, the subject matter expertise and the legal expertise to deal with absolutely all areas. And so the Ombudsman's broken up into multiple areas. These are in the Act itself, where they've just gone and created little subgroups. So there will be the Defence Force Ombudsman, or the Immigration Ombudsman, the Postal Industry Ombudsman, and so on. But no, when looking at this, these are federal areas. These are things that there's either a power under Section 51 of the Australian Constitution that says the federal government's responsible for defence, immigration, the postal service. There's some other things, though, that have popped up over time. If we think about what the Queensland government does, well, you know, education and health, those are areas which the states have historically had domain over. And that kind of was the case. But as we're aware from constitutional law and things like the work choices case, as the federal government gets more and more cash, starts to do more and more things and has more and more power to legislate, thanks High Court, they find that they take power and then don't give it back. And so things that have cropped up in recent times, vocational training under the VET scheme, funded through the federal government. As a result, federal government's taking care of that. Federal government will go and establish an ombudsman for that in particular. Similarly, overseas students. Admittedly, that probably falls within your foreign affairs things as well, but by and large, that's taking a component of the education sphere, which has historically been the states, back towards the federal government. And again, the private health regime, which popped up, I believe, and anyone correct me on this, I believe in Australia it popped up in the 90s. Sounds like the sort of thing Howard would have done. But I can't confirm the date for that. Either way, that was driven very heavily by the federal government. And it integrates with your income tax system. Now, these bodies created by statute, and most of them in the actual Ombudsman Act itself, in the little here's a new section, oh, we need a vet student loans ombudsman, oh, here you go, we'll do it here. And we just plop these things in. However, Australia, in terms of us as consumers, Australia has a lot of big players. Things like your supermarkets, your banks, your insurance companies. You have big players and they have a lot of power. Those industries, and I have said in the 12 years that I've lived here that I reckon they milk you guys, Coles and Woolies, IGA. But your big players have so much market power. And by and large, they use that market power to be quite profitable. And what they've realised, though, in this contemporary regulated day and age, is that they can't carry on like it's the year 1918. It's 2018. They can't rely on people having difficulties or dramas with their airline or with their telco or with their mobile phone provider, the bank, being able to go trot off to the Supreme Court to seek some form of remedy. This just doesn't work at all. And in practice, you guys are very much in the minority in terms of the amount of law that you know And you are going to be horrified when you finish doing your degree and do your PLTs and then go out and work in whichever area you end up with. You will be horrified how much you do not know, because law, and particularly this system of delegated regulations that are created, is massive, getting bigger and more complex at a faster rate than you can learn it. And that is a terrifying thought, to think that we, as legal practitioners, can't keep up with all of the law. Imagine how people that don't have 4 years of structured legal training, practical course, and the system for admission, which involves some form of work experience as well. Think of how your grandparents, I don't know if anybody have grandparents who are actually lawyers, but think how they have to go about dealing with these sorts of structures. And what we've realised is that, look, you have to have bodies that step in. And with the industries, they're a little bit switched on, your banks, or perhaps not. I don't know, for those that have been following the Royal Commission. But the large players, by and large, realise that if they do not create their own little industry watchdogs and fund it and give it at least an aura of independence, the federal government's going to come and do it for them. And if the government comes and does it for them, they are going to strike them down with furious anger and heavily regulate them. So they basically have taken the initiative with a bunch of these things and set up their own bodies. Now, these are all done in consultation with government, but generally they're funded by industry. And so trying to have that balance, let's have our own watchdog and try to make it as independent as we possibly can, because if the Commonwealth Ombudsman jumps in and does the same process, it's going to go bad for us. And so that's how a lot of these things sit in terms of that system. It's trying to achieve that sort of balance. And by and large, again, Banking Royal Commission may not completely agree with me. By and large, they seem to work all right. I'm not an expert in that particular area, and I don't know if any of you guys here have had to deal with any of these sorts of independent bodies. The financial ombudsman, who have difficulty with your insurance company, for example, or loans of some sort, going and dealing with those. Having this independent body means that it's a one-stop shop, because the other thing they do, as well as investigate, is refer. So you go there and they'll say, look, you may have a case, but you're going to need to go and get a lawyer and go to the AAT or go to QCAT or what have you. Does that kind of make sense? Kind of sense? That's basically they're just stepping in to try and remove lawyers from the process. This is a very common theme. In fact, all of your legal education, you would have seen this. Oh, we have to have internal reviews first. Oh, we have to go to a tribunal where the rules of evidence don't apply, or mandatory mediation. Trying to remove lawyers and the mechanics of the law from this process to give citizens more power to do things. But just leave on the back of your mind, remember, all of these bodies, like the Ombudsman, Commonwealth Ombudsman, they have the power to investigate and report and refer, but they don't have the power to actually make changes. They actually say, no, you have to do it this way. What you'll find in practice is that if the Ombudsman says something, hey, government department, you're doing this wrong. Here's the law. We believe it should be this. Do you want to change what you're doing? Or do you want to, or you want to go to head-to-head, and we'll take it to the federal court. So they can go, again, of their own volition or through a complaint, and look at these things and tell government departments they're doing things wrong. And by and large, government departments are quite responsive to this. Okay, sure, we'll let it go. Change the way we go and do our internal processes to deal with this. And sometimes they put the gloves on and they trot off to court. All right. So if we've got the Commonwealth areas, the ones that we know about, flowing from the external affairs power and the defence power, and these things the federal government's jumped in and grabbed, the private health insurance and vet training to do with student loans and so on. But there's still a whole bunch of Queensland bodies that are set up, are designed to be independent and funded, either some through industry and some through generally the Queensland government, that has the power to investigate certain matters. This is a non-exhaustive list. There's certainly way more. In fact, that bottom one, local government issues, things involving the council, footpaths and roadways and rates and all of those sorts of things. They set these things up, again, to have this independence. And to make it easier for the citizen to have this first step to go to. Hey, I don't know anything about the law. I've heard there's something called the Ombudsman or the Commissioner for Fair Trading or what have you. I'll go there first. Usually you do your Google search first. And those things appear quite high because they pay Google a lot of money. And then people can go there. And look, sometimes the advice from these independent bodies is you need to get a lawyer. You need to go and do this actually through the mechanics of law. Sometimes they'll say, just leave it with us. We'll do an investigation. We'll trot off and get back to you with our findings on it. Sending, please explain to the relevant government department. Okay. Now, one of the key things about independence, you guys remember Gillian Triggs? She might be still the Human Rights Commissioner, and how she got criticised by the then government of the day because she was doing a bad job. One of the hallmarks of these bodies that are created by statute to be independent is that the staff that are in them have tenure. You guys know what tenure means? It's like academics used to have tenure. Well, that meant you couldn't fire them. Once you had tenure, they had to have some sort of proven misbehaviour. And that's actually quite similar to how these independent commissioners and ombudsmen are set up. Hey, we're appointing you a responsible person to be the ombudsman for this particular area. Here's a pot of money, usually quite a lot of money, and we can't fire you. You'll have a term, usually renewable term, but the government can't remove that person. It's a bit like judges. How do you remove federal judges? You know, remember? Go on, go back to stage one. How do you remove? Yeah, well, yeah, win the 70, that's right. Well, that happens by mechanics of law in your constitution. If they've been naughty, how do you remove them? What's the process? You've got to have a joint sitting of Parliament with the Governor-General and Council with proven misbehaviour. These things, and you'll be maybe not shocked and surprised to find that removing Ombudsman follows a very similar structure. Governor-General may remove an Ombudsman for office on an address praying for his or her removal on the ground of misbehaviour or physical or mental incapacity being presented to the Governor-General by each House of Parliament in the same session of the Parliament. Very, very similar to how you remove judges. It's trying to have that level of independence, and you need to give people tenure to go and do things. Just make note, there is bankruptcy. Is also a mechanism for removing that. And again, section 28, subsection 8, an ombudsman shall not be removed or suspended from office, except as provided by this section. So if you were the government, how could you go about actually removing them? Well, you'd have to amend the Ombudsman Act, because this is still an act of Parliament. If you wanted to, you could just repeal it. We remove this, and we make this person redundant. Because we have a Westminster system, the government is usually made up from MPs that make the majority house in Parliament. And usually, that means that they have the power to legislate. Not always. Sometimes you've got minorities. Sometimes you've got senates that stop such things. But in theory, that's always a thing. Now, in some countries, the Ombudsman is a constitutional office. So, again, it's no coincidence that this reads like the Australian Constitution, but it is an act of Parliament. It can be repealed by the Parliament through the normal passage from a bill turning into an act. It is not a constitutional document. Some academics think that we probably should move to make these things constitutional. I think it's pretty low priority, but throw that out there. So what can they do? What can the Ombudsman do? They can investigate. They actually have quite a lot of statutory power to achieve the particular purpose, to investigate these particular complaints. And that power under statute actually extends to bodies that provide services to the public, but are strictly speaking private entities. Remember, we had difficulty in terms of judicial review, in order whether or not it's justiciable, in order to seek a remedy from a private body, has to really be exerting or doing some sort of public function. Well, that idea of being able to essentially pierce the arrangement, to pierce the veil in terms of this outsourcing, very common thing in governments these days, trying to outsource something. Oh no, we need a detention centre on Nauru. Let's hire a construction company. They can set it up and they can run it, and they can make all the decisions for it. We'll just fund them through a contract. That's the instrument. So therefore, it's not us making decisions. Not sure about that. But in terms of the Ombudsman, they have a stat power to just burst that bubble and go through and investigate private bodies. What have I got? 36. All right. I probably wouldn't copy all this down. This is from the statute. It's basically limits to what they can't do. What can't they do? They cannot investigate things the minister does. There's one thing about the Ombudsman in terms of what they do. They're independent, and they can sometimes, cut through all of the rubbish that's been put into place in order to obscure an issue. But if the minister does something, the minister chooses to deliberately do something, that's not for the Ombudsman to investigate. Ministers make political decisions. And so that's something to just make note. And also, clearly, the Ombudsman's not empowered to investigate decisions of courts. Sounds a bit dumb from us as law people. They're not there to look at the lawfulness of what the federal court or the high court does. It's not their job, not their role, and they're forbidden by the statute. Yeah, there's some things, there we go. So there's some specific exceptions there in terms of, I think it's employment. The APS, you guys, for those that are involved in the federal government, the APS, that's the 99, I think it is their legislative framework for employing Commonwealth bodies. I got to know that one section of that legislation particularly well because section 19, can't remember, it was a few years ago now, that says you can't work for the federal government unless you're an Australian citizen. So those that aren't Australian citizens, good luck trying to get a Commonwealth job. Good luck. I literally had the world's shortest job interview. Are you an Australian citizen? No. Well, there's really no point continuing, Mr. Walker. I have to escort you from the premises. Okay, so just make note there. Proceedings of Parliament as well. That's that AA at the top. So things that Parliament does is not really, it doesn't really involve the Ombudsman. So they get their little sticky beak out of it. So, what powers do they get? Well, the power flows from section 9. It's quite long. There's actually there's 3 slides of this, so please don't copy it down. Just make note. Section 9 says, when the Ombudsman has reason to believe a person is capable of furnishing... I'm not going to read the whole thing out. Basically, if the Ombudsman thinks that a person has documents, they can go and coerce them. Here's me saying they didn't have coercive powers. They do in regards to investigations. They can make that particular body or that private citizen, remember, if that particular private citizen is contracted to the government to do things, they can make them produce this information. Give us the documents. And if they believe a person does have documents but aren't handing them over, they can make them, they again have this coercive power, almost like contempt type powers, to make them appear. And there are penalties that flow again from the statute if those people don't do that. A lot of these things flow, by the way, from giving notice to the principal officer of a particular agency. So there'll be a particular person for every stat body who was the person who receives notice from the Ombudsman that, hey, we're doing an investigation, it's to do with this, this, and this. Give us the documents, or else. What do? Once they've got the documents, they can make copies of them, take extracts from them, and what's what I put in there? Yeah, and just retain them as well. They can retain possession. So one of the things to note when you guys learn, for those that are doing criminal law, or if you're involved, I believe Malcolm still teaches the advanced crim subject. No, it's not around anymore. Paula, oh boo, okay, well. Okay, for those that do tax, you'll learn about the coercive powers. I know it might be advanced tax as well. If you do the advanced company law subject, you'll learn about the powers of ASIC. Please tell me that hasn't been pulled as well. Okay, if you do Tom's advanced company law subject, it talks about the power that ASIC has. If you did the advanced tax subject, it talks about the power that the ATO has. And again, in criminal law, Malcolm talks about the powers of the federal police to go through and do things. So here we're talking about the Ombudsman, powers that they have to go through and do things. And you'd be amazed which of those bodies has the strongest power. It's the tax office. They can do anything. It's amazing. They vaguely think you've got anything to do with tax. It kind of makes sense though. Everything else doesn't work if there's no revenue, if there's no money. So anyway, that's the power, where the power flows from the Ombudsman to just rock up, grab your stuff and take it away. And again, look, for you guys as citizens, if you're not contracted with government agencies, this shouldn't concern you in terms of what the Ombudsman can do. If you are involved in government or quasi-government agencies, particularly private bodies that contract with governments, just make note that these powers might apply to things that you're doing. All right. Oh, gracious. Okay. Can they say no? Yeah, there are some things. And again, some of these things can go off. I believe there's a separate commissioner that can go off if things, handing over the documents to the Ombudsman, might endanger the life of a person or create a risk of serious harm or injury. Yeah, sure. That is a high bar. And again, for those of the lecture last week, we talked about the Information Commissioner when the example that I used was the Crown Casino, how they had the little subcontracted air services company, and they tried to argue, if we give out our air flight records, it might endanger the health and safety of our high-flying patrons. Good luck. Good luck with a whole host of these. It has to be something a lot closer to the core in terms of usually the things to do with national security and imminent harm. Okay, now there's some interesting here. This is one of those few times. Has anybody studied legal ethics and done? You guys probably do it next year. When we talk about legal professional privilege, this is one of the few times where a statute will actually trump, in some instances, legal professional privilege. Usually, the court gives it a really high bar. Information that's produced in confidence for the dominant purpose of providing legal advice, can't be coughed up to bodies. It's protected under this fundamental common law right and rule from, in the case of Esso Petroleum. But, as we know, when you've got express parliamentary intention and ye old common law rules, who's going to win? These guys. And so, in some situations, and look, here it kind of makes a little bit of sense. In terms of legal advice, this is legal advice that's occurring inside government departments. All right? And if you kind of think about that, if you're a government agency and you hire a whole bunch of people, all right, some of them might actually be lawyers and they may be giving advice from one person to another. So you've got this government agency and then you've got little pockets where legal professional privilege might arise. And that can be a little bit problematic in terms of how the Ombudsman functions. Again, it's all a government department. From our perspective as citizens, is there really a difference from the outside between advice that's given, legal advice that's given inside a government department and non-legal advice that's given, or advice that's given by a non-lawyer to another person. You know, it seems a little bit problematic to not allow that. So this is an area, one of the few, that'll pierce privilege. If this comes up next year, be nice to Jamie and don't keep pointing these things out, because he teaches legal ethics, and it's a tricky class to teach. So it's just a piece of thing next year. Please be kind to Jamie. It is a hard area to teach, and largely because you're teaching people to be ethical. Yeah, just think about that. All right. So, if you're doing things as part of Ombudsman investigations and you cough up some documents, can you be sued? Well, Parliament's jumped in here and has said, look, the whole purpose of the Ombudsman regime is for people to be able to make complaints and have them heard and have the relevant Ombudsman go and investigate it. If we have a situation where people are getting sued, it creates a massive disincentive. So as a result, this going and furnishing of documents or the making of complaints themselves are immune from civil liability. Was it section 37? All right, so they've done this investigation, so what? Well, as I said earlier, section 12, the Ombudsman has no coercive powers. They can get the stuff and coerce people to give them all of the information. So what? What happens? Well, a couple of different things. It can, first of all, it can tell the relevant government department, look, you're doing this wrong. Sometimes they go, oh yeah, mea culpa, let's fix that. Sometimes they don't. And they said, put the boxing gloves on, take it to court. Usually they advise people to take court, but they can bring things and refer matters of their own volitions. Questions can go to the AAT, or questions can go to the federal court, 10 capital A and 11 capital A. And where a government agency's done something really bad, where there is more than just you know, a procedural matter, they've actually made a stat breach, or there's some form of misconduct, they can refer that to the minister themselves. Now, one thing about this independent nature of the Ombudsman is that they report this stuff back to Parliament. Now, they physically don't rock up to Parliament. No one except MPs, in theory, unless they're invited by the Parliament, can rock up to Parliament and address them. But the statute says when the Ombudsman makes a report to Parliament, the minister must go and present this. The minister is obliged to rock up. I'm not sure whether it's the Attorney General. I'm actually not too sure who the relevant minister is there, but they are obliged to table this report in Parliament. They're obliged to go through and do that. Now, again, usually this is where things have broken down. If something problematic has happened, and particularly where the ministry is in conflict with the Ombudsman over something, or the relevant, and this is similar for other statute frameworks too, although this is the Ombudsman Act. They have the power to go and say, oi, statute says, in this report that we've produced, you have to go and table it. You have to explain it to Parliament. What does that mean? Fundamentally, you're having to explain to the world, to the Australian people, what has happened and what the Ombudsman actually thinks. And really, it ties into this idea that we've had throughout this particular subject to do with, ultimately, the government being responsible to the citizen. And that's fundamentally what this entire subject was about. And with the biggest smile you can possibly imagine, that is the official end of the content for this subject. Yeah, I told you to be smiling. And so, I guess for the sake of the recording, thank you for having me. We will be having a lecture in this exact spot next week, when we'll go through and do revision stuff. But in terms of the content that you guys are armed with, and again, there's some things we'll talk about, you will have to go through and do some future bit more research on in order to have comprehensive answers inside your exams. But by and large, we're done. So thanks all for having me. Hope it wasn't too horrible. Hope you enjoyed the guest lectures today, and we'll see you in tutorials very soon. Thanks, team.